Good evening, everyone, and welcome to this live stream all about Teletext holiday refunds. Now, of course, we shouldn't be here this evening. You shouldn't be having to waste your time watching me on YouTube, but we are here. We all know why. And also, I should say good evening to the Teletext representatives who I know are watching as well. And I'm hoping that some CMA people are watching and some people in the wider media. Now, let me just remind you what this is all about. Of course, we all know everyone on this live stream is waiting for a refund from Teletext. I want to do three things this evening. First of all, I want to collate some evidence for the CMA. So that means I'm going to ask some questions. They'll come up on the screen, and I'm just looking for you to say, yes, that applies to me, or just yes or me. The idea is, I'll give you an example. In a minute, I'm going to ask who's been waiting for up to 6 months for their refund. I'm looking for people who are in that position to say me. And therefore, what it will do is when I give this to the CMA on the playback, they will see the numbers of people that are still affected. I'm trying to really show consumer detriment, because that's what this is all about. When the CMA, the Competition and Markets Authority, see consumer detriment, that's when they have to get engaged. Now, I have been in communication with them. I've been telling people about this. They have been responsive. At the moment, there is no official investigation, so far as I'm aware of. But I think the more we keep pushing them and the more we keep showing this consumer detriment, words I'm going to use a great deal this evening because I know that's what works, the more likely it is that they will jump in, meaning that you won't have to do things like court proceedings and all the other things that I'm going to be speaking about this evening. Now, once I've done this part and I've gone through the evidence part of the call, of the live stream, I'll then move on to some tips and advice that I've got about how you may go about solving this issue, or I should say how you may go about getting your money back. And then I'll move to a question and answers system, a bit like what I do on LBC Radio. If any of you have heard me on LBC on a Friday night, throw me your questions. I'll answer as many as I can. I really want to try and help as much as I can. That's what this session's about. So just ask me all you want to ask me about the issue. I'll answer as much as I can. I'm going to try and structure it a bit as well. So when I get to the Q&A, I'm going to ask you who has questions about Section 75, chargeback, court proceedings, and so on. I can already see quite a few questions coming in. I will get to them in a second, but let's start off by going over the CMA side of the call that I want to deal with. So give me a moment. By the way, first live stream I've done, so bear with me if it goes a bit clunky. Hopefully it will be okay. So I asked you this a moment ago. And what I'm really looking for now is, if you have been waiting for up to 6 months, not more than, up to 6 months for a refund, please can you now type in me on the chat thing? I'm just going to give you some time to do that. Or yes will work as well. And again, the reason I'm doing this is that hopefully this will give the CMA a much better feel for the amount of people that are greatly affected by this. The timing is important because we don't know what Teletext are telling the CMA. There's bound to have been some contact established, and we don't know what they're saying about timing. They may be saying, well, no one's been waiting that long. That's why I want to do this. I want to show firsthand from you as the customers how long you have been waiting. Don't tell me if it's over 6 months yet. I'm going to ask that question in a moment. So I'll leave it a few more minutes before I jump to the next part. Okay, so now if you've been waiting for more than 6 months, please now tell me that. Just say me. Or exactly 6 months, as someone just said. I wasn't going to ask this, but if anyone's been waiting for more than a year, Not sure if anyone would have been. Can you tell me that as well? And there's a reason for that, because that's when it gets a little bit more serious. No one should be waiting 12 months. Look, no one should be waiting 3 months. But if anyone's been over a year, I'd be very interested to see that, because I will contact you individually if you have, and provide your actual individual case file to the CMA, because they will be very interested if anyone's over a year. If it is you over a year, don't say me, just put I've been over a year, just so I can distinguish you from everybody else. 11 months I've just seen there. Just amazing. No one over a year. I wasn't expecting anybody over a year, by the way, but of course we know you're soon going to be. Okay, I'm going to move on to the next question. How many have you received multiple promises of a refund? Now, I know the answer to this is going to be yes, because lots of people have told me, just give me a number. If you've been told twice it's coming, given a date, hasn't happened, just give me the number. Of course, the CMA will be able to hear my question on the playback and then see your number. Too many. If you can give me a number, it helps. 6 promises, way too much. And you can see this is building a really good picture, because when people say, like Kane there, 5 to 8 times they've been waiting for months and months, sometimes more than 6 months, you can get the picture. There is a major problem here. Consumer detriment, CMA have to investigate. Again, this is what I'm trying to achieve with this. So keep rolling those numbers in if you can. I've just seen someone say 10 times. Again, that's just amazing. Great evidence for the CMA. How can you promise someone a refund 10 times in a row and just not provide the refund? This, for me, and I'm going to keep saying this, I'm not trying to repeat myself. I'm doing this for the benefit of the CMA. That's too many times. Too many times. Something's gone wrong. This has to be investigated. I see there someone says that they've had 3 credit notes in the wrong name. Now, a cynic will say they've done that on purpose. I'm not saying that. Of course, I can't say that. But if anyone else has had the same experience, please tell me. Again, it's all good evidence. Before you ask, that's water, not vodka. Okay. By the way, anyone who's asked me a question so far, I will come back to it. I'm just going to get this part out of the way first. Now, I've heard this a lot as well, where Teletext has said, we can't refund you yet because we're waiting for the airline, or perhaps we're waiting for the hotel. I think it'll be the airline more often. And many of you have told me that you know this is not true because you've gone to the airline and you've asked the airline, and they've given you an email or something like that, letter, text, to tell you that they've actually refunded. If this applies to you, then please tell me now. You can just put me again, because again, the CMA will hear my question. But it's really important, this, because this, if this is factual in every case, is an example of Teletext not telling the truth. And again, I make no accusations on this live stream. I can't do that because I don't have all the evidence before me. Although certainly I have seen some evidence from consumers showing me the airline has paid. So if that's you, please tell me so we know. I'm just watching some of the responses coming in. Seems like quite a few people are in this situation. I'm just going to ask all those people that are telling me that, yes, that applies to me, i.e. the airline has confirmed that they've paid. Are these situations where you've gone back to Teletext and said, actually, I know that you have been paid. Here's the evidence. Has anyone gone back and told Teletext that and still been ignored? I know that's happened to some people because I've heard it seen it on Twitter and on emails, but how many people have really had that? Okay, going to move on to the next question, which is about Section 75. Don't get too concerned about Section 75 yet, if you're not sure what that means, because I'm going to come back to it. But if you have made a Section 75 claim because you paid with your credit card and it's been rejected, can you tell me, just put S75 rejected in the questions here so I can see how many people have done that. So why am I asking you this now? Because it's consumer detriment, because you've taken the trouble to make a claim, you've had it rejected. Therefore, that means that you've had the stress of that, which I know is not nice, because lots of people come to me about Section 75 rejections. And it's another thing the CMA have to take notice of. I'm going to quickly say this about Section 75, and I am going to say more about it in a little while. I always tell people when I'm doing LBC on a Friday night, if you make a Section 75 claim, they will, for some reason, always reject your claim to start with. Nearly always, I should say. And I'm nearly always right about that. If you then go back for a second time, often they will accept it. That's what I believe will happen here. I'm going to tell you a little bit more about it in a moment. But I'm amazed. I can see lots of people coming through telling me Section 75 rejected. Look, my view on this, my very, very strong view is all of your claims should not have been rejected. I think I know why. And again, I'm going to explain it in a moment, but interesting to see how many have been rejected. That's just wrong. In some cases, it may well be down to responses that your card provider got from Teletext. I don't know, but we'll look at that in a moment. I'm going to now move on to chargeback. This is where you paid by your debit card and can take advantage of the chargeback scheme. So how many people have, by the way, if you've been rejected for chargeback because you are more than 120 days, don't tell me yet. I'm going to come to that in a moment. But how many people have made a chargeback claim only to be told by the bank, sorry, no? If that's you, put chargeback rejected. So some people have not heard back. Interesting about Section 75. Some people saying they got refunded and then it was rejected, i.e. decision overturned. I'll come back to that. That's quite common, I'm seeing with the Teletext situation. Lots of people telling me the same thing. More chargebacks rejected. Again, not surprised by this. So I'm going to move on then to with chargeback, how many people had it rejected because, or perhaps they didn't claim, you didn't claim because you're now over 120 days. And by the way, I'm guessing that if you're over 120 days, the reason you got there was because you believed Teletext were going to refund you. That's what people are telling me. If that's you, just put over 120 days. We'll then know what that's about. So a few people saying that's them. And I keep on pausing, by the way, because I just want to see the answers coming in. This bit is all about the CMA. So I want to make sure we drive this home here and they can see what this is all about. One thing I want to quickly say here, I know there's some people on here that are running Teletext groups. At the moment, we've got 104 people live online. It's great. I know there's many more people than that with this situation. We, of course, need to drive this home to the CMA to investigate. So I will encourage you afterwards to push people to, I'm going to see if I can perhaps find out if I can get people to comment on this when we're not live later. If so, push people to come and do that. We need more evidence. 105 now people is good, but I know there's way more than that. We need everyone, as many people as we can, to come forward and to tell us their experiences so I can package it all up and send it off to the CMA and see what they have to say about it. And someone says there are at least 900 in this situation. And that's been my understanding, actually. Lots of people have been telling me that as well. I think there's more than that. I think there's 900 in one group alone from what someone was telling me earlier today. So it's going to be way more than that, I think. We need everyone to come forward and tell their story. So I'm going to move on next. Has anyone issued proceedings in the small claims court? Now, I'm saying small claims court, that's ordinarily for proceedings up to £10,000 in value. Most of these holidays, I think, will be below that. So if you have issued proceedings in the small claims court, because your claim was under £10,000, or because perhaps the court felt that you were okay to go there, please say SCC me or something like that, just so I can see how many people have issued proceedings. Again, I'm going to come back to this in a moment because and give you a bit more information about that. But this is just about, if you're just joining the call now, I'm just collating evidence, your responses to my questions to package up for the CAA. So I'll let that run for a moment. Amazing amount of people who have actually issued proceedings. Again, should never have come to this. When you book a package holiday, historically, when people have asked me, I'm going to book a holiday, what's the safest thing for me to do? My advice has always been pay with your credit card because of Section 75. I'm going to come back to that in a while. And book a package holiday. Nearly all of you have booked a package holiday. I'm taking the assumption that's the case. And despite that, here we are. Who knew that this would ever happen like this? And I know we've got a pandemic, but the pandemic does not change the law. Despite the fact that some holiday providers and traders would like to think that it doesn't change the law. The legal obligations are still the same, yet they've been flouting the law. This is just wrong. This is why we're having to do this. And all of these answers you're giving me are going to help. Amazing amount of people that are starting court proceedings. Some people saying they're starting tomorrow. Good. Make sure you listen to what I'm going to say this evening about that, because there's some key points to make about court proceedings. If anyone has issued proceedings in the what I call the full county court, because it's over £10,000, can you tell me that? Just put full CC. I don't think there'll be many. Sorry, someone just told me that I said CAA. I would have meant CMA, Competition and Markets Authority, not the Civil Aviation Authority, just to be clear. And thank you to the person who pulled me up on that. So anyone issue proceedings in the full county court? Just amazed by an answer I just got there. Court proceedings started and TT have asked for 14 days more. I mean, why have they asked for more? Because there is simply no defense. They shouldn't be asking for more. I think you'll find they're doing that simply to drag this matter on. They will have to pay you. They won't want to have a judgment. That's why they're asking you for more time. Where possible, I'd go back and say no. Ordinarily in litigation, we do allow other parties more time. This is different because this is a situation where they're asking for more time just to drag it out. Now, if you say no, of course, the court may say yes, but I wouldn't make this an easy ride if I were you. That's my top tip about time extensions of court proceedings at the moment. I'll just leave it another minute for people to come back with any answers. Okay, so those are all the questions I want to ask for the CMA. Of course, the CMA is going to see all of this anyway, but those are things that I'm going to wrap up as consumer detriment. I said I was going to say it a lot of times. I'm seeing it through. I am. What I want to move on to now is more about the law. Now, I mentioned Section 75, and what I want to do here is I know that there will be many people that did pay for their holiday via a credit card or with their credit card. And if this is you, if you paid with your credit card, it means that you can use Section 75. Now, those that know what this is about, forgive me, but there may be some people that do not know what it's about. I'm always amazed when I do LBC radio or other things, how many people have just never heard of it. And for that reason, I'm going to quickly give an explanation. So when you pay for goods or services on your credit card and the purchase price is more than £100, which is going to be here, doesn't matter if you spend the whole £100 or more on the card, as long as the price is more than £100, you are potentially entitled to use this Section 75 protection, or sometimes I call it an insurance policy. The price also has to be less than 30,000. I think, again, I imagine most of these holidays are going to fall within this bracket. And if you are within this remit, the 100,000 to 30,000, you can use Section 75. Now, what this says, and the law dates back to 1974, and the law says if something goes wrong, so if we look at that here, what's gone wrong is you've not got your holiday, it's had to be cancelled, they've not given you a refund. If something goes wrong, the credit card company steps in your shoes and gives your money back. Now, I know that many people, I know from before today, but also from the responses I'm seeing you're giving me, many people have had these claims rejected. In a minute, I'm going to ask people to tell me why in as short a sentence as you can give me, very brief, but I'm going to guess why it's been the case in most cases from what I've been hearing, because what will happen is you make the claim to the card provider, they go to Teletext come back and give a reason for why the Section 75 claim should not be successful. Now, I'm going to go a little bit more legal with this because most people who talk about Section 75 will say, like I just said, actually, if something goes wrong, they'll step in the shoes. It's a bit more technical than that, because if there's a breach of contract, that's the key term. If there's a breach of contract, then the card provider will step in with Section 75. So what's the breach of contract here? Very simple. The package travel regulations, for those of you that are on a package holiday, or should have been on a package holiday, I should say, they provide terms as per your contract. So your contract with a holiday provider will say, we're going to send you on holiday, you're going to pay this much, you're going to take this plane, and all the other things about the holiday. But in addition to those basic terms, these regulations, these package travel regulations, also put implied terms in. That means what those regulations say become part of your contract with Teletext in this case. One of those terms is that if the holiday is cancelled, not by you, but by them, or it can't happen, as in this case, because of the pandemic, they will refund you within 14 days. Now, of course, that's laughable, because in this case, here we are, you've all just told me, many of you, we've waited for 6 months, we've waited for more than 6 months. One person said, I've waited for 11 months, 12 months next month. So the 14 days has gone out of the window. But let's drag that back to what that means in law. It means there's a breach of contract. And because there's a breach of contract, if all of the other conditions are satisfied, i.e. it's more than, I say £100, I'm just going to, I don't want to get too technical with this. It's actually £100 and 1 penny. Many people that talk about Section 75 don't know that. I'm not labeling it too much because most of you, I can't imagine any of these holidays were less than £100 and 1 penny, but that's what it says. So if it's less more than £100 and 1 penny, less than £30,000, and there's been a breach of contract, here there has, you're entitled to claim. So these card providers, when they have rejected your claims, they are wrong. So let's look at why they've been rejecting your claims. I think you'll find that Teletext would have been telling them, we're going to refund them, or we've offered them a credit note or a voucher. Therefore, there's no breach of contract. And I know that some card providers, or I should say maybe many card providers, have been accepting that and saying, yep, there's no breach of contract. Some card providers have also been told, well, we've got a force majeure clause. Anyone heard of that? What that basically means is there's a clause in the contract or in your terms and conditions that says, if there is an act of God, apparently a pandemic is an act of God, and the holiday cannot go forward, we're not liable. Now, where they do have a clause that mentions pandemics and covers COVID, they're right. But that doesn't mean they're not liable to refund you. It means they're not liable to give you compensation for the holiday not going ahead. I've not heard anyone, I don't think any of you on this evening, come to me and say, I want compensation. You just want your refund. And the reason I'm waffling on about this is because I'm trying to explain why these Section 75 claims should not have been rejected. So the whole force majeure clause is irrelevant. The whole thing about, well, we've offered the customer a voucher, a refund, but we're not giving it to them yet. All irrelevant. The only relevance here is you've not got your money in your bank. You didn't get it within 14 days, and that means there's a breach of contract. So I think some of you may have started to tell me. I'm going to have a quick flick through as to some of the reasons why you've not been, or why you have been rejected, I should say. Give me one moment and let's pull some of them up. Okay. So forgive me, I'm going to put some of your questions on the screen for everyone else. My bank told me that I had to go to Atoll before I could action the Section 75, despite me paying with my credit card. Guess what the answer to that is? No, wrong. That's not what the law says. Let me give you an analogy. Many people tell me that when they make Section 75 claims, again, in relation to retailers, sofas is quite a common one. So they go and buy a sofa or something like this. Something goes wrong. Perhaps the sofa doesn't arrive, or it arrives with one arm. That does happen from time to time, or something else. You could go direct to the bank and not even tell the retailer and say, this sofa's got one arm. I want my money back. Section 75. What a lot of car providers do in those situations is they come back and say, did you go to the retailer? And you say, no, we've got to go to them first. They're wrong. They're wrong because the law, which by the way, we've had since 1974, clearly says you don't have to do that. Something goes wrong, i.e. breach of contract, you can go straight to the bank, or sorry, to your card provider and claim Section 75. So the answer here to Cara McLean is your bank or your card provider is wrong. You can go back to them and say, there is no legal obligation on me to do that. Section 75 of pen moment, the Consumer Credit Act 1974, do write that down, does not anywhere say I have to go to Atoll first, a retailer, a trader. I can come straight to you. So the good news there is that's not an excuse. Let's go to the next one. This is the question. Leah, is it right a Section 75 has no time frame to get your money back, as our credit card has just told us that? Yes, that's correct. Let's look at comparison here. So chargeback, we were mentioning the 120 days. That's one of the major drawbacks of a chargeback claim. The other drawback is that it's not the law. So you've just heard me mention this law that we got in 1974 in relation to Section 75. Chargeback isn't underpinned by any law. All that happened is all the banks, all the debit card providers got together and agreed they would do this thing called chargeback, and they would allow you to go and make a claim. But they put this time limit of 120 days on it. But coming back to Leah's question here, there is no such deadline with Section 75. So if you haven't made a claim yet, it's not too late. You can still do that. Great question. Thanks for that. What happens if the credit card you paid on has expired, or you change your credit card due to fraudulence? Will your money still get paid back? That's a brilliant question, which actually many people ask me about. The answer to that question is it doesn't matter. All that matters is that you paid on that particular credit card. The purchase price was more than the £100 and 1 penny, and it was under £30,000. Doesn't matter if it's now expired. You took out that effectively insurance policy, as I call it. By the way, it's not really an insurance policy. I just call it that. But you took that out the moment you paid on your card. So if it's expired, it doesn't matter. Of course, fraud on credit cards is now very common. It's very common for us to get a call to say someone's used your credit card, or your details have been found on the black market. Therefore, please cut it in half. We'll send you a new one. Well, if it meant that Section 75 didn't apply when that happened, there'd be many people who would have claims rejected. By the way, I have heard card providers say, sorry, you've not got your card anymore, you can't claim. They are wrong, which is why this is a great question. So don't take that one either if they say that. Next one here. They told me that I claim after the 120 days. Sandra, I'm guessing that's a chargeback claim that you're talking about. If that was a credit card claim, i.e. a Section 75 claim, and you're sure it was a Section 75 claim, because you paid on your credit card, I would love to hear from you, because that would be the most ridiculous reason for a rejection I've heard for a long time for a Section 75 claim. But do let me know. But I think that's a debit card claim, but let me know. Next one here. Tesco's credit card said Teletext didn't breach their contract with us. Teletext claim our holiday wasn't a package despite booking flight plus holiday at the same time through Teletext. This is an interesting question. Now, look at the words, didn't breach a contract. Remember what I said at the start? It's all about a breach of contract. And card providers will latch on to the breach of contract element, because if the likes of Teletext tell them there is no breach of contract, that's a good reason for them to say no. Now, I'm just going to say this here. Forgive me. This is a bit of a disclaimer. I haven't seen the papers in any of your cases. So I'm taking as read all what I'm being told. I'm giving you generic answers. Teletext, Tesco's card in this case, are not on this stream to put their position across. So this is a generic response. What the case will be if everything you're telling me is correct. You know why I'm saying that? I have to do that. So if in this case, if this is a package holiday, so if Teletext were wrong, or if Tesco credit card just got the whole thing wrong, then of course there is a breach of contract. There's a breach of contract because they failed to pay, in this case, Sarah back in 14 days. So that Tesco's credit card would be wrong. Ordinarily, if you book a flight and accommodation together under the regulations, that will be defined as a package holiday. My advice here is have a look at your paperwork, see if you were given an ATOL and or an APTA certificate. If you were, these will tell you that it's a package holiday, and that will be good evidence. Again, I've not got it in front of me, so it's always difficult in this situation for me, but it sounds wrong. It sounds like another reason why a card provider is just jumping very quickly to say no. Again, my advice, go back again, ask the question again, because I think you'll find they may well come back and say yes. Yep, this is another great question I get asked a lot. I paid in installments and paid some on debit card and some on credit card. Can you still do Section 75 for the whole refund? Answer, yes. I'll give you another example of this. Let's say you had paid £10 on your credit card and all the rest by a bank transfer. You can still claim the whole amount on Section 75, as you can if it's with part debit, part credit card, or any other method of payment. The important point is this, that the purchase price, as in this case, the price of the holiday is more than £100 and 1 penny and is less than £30,000. As long as you're in that bracket, doesn't matter how much you spent on your credit card, you're entitled to claim Section 75. Again, great question. I'm just going to look for some more. I paid on credit card and told it was 120 days. Can credit cards still do chargeback? Okay, I think there's two questions there. Let's reverse them. First of all, can you do a chargeback on a credit card? Answer, yes. So when you pay by credit card, you have a choice. You can claim under the chargeback scheme, or you can go Section 75, or you can do both, but not at the same time. My advice is, if you're still within 120 days, is to try the chargeback scheme first. The reason for that is it means that the card company effectively grabs the money back, so they're not out of pocket when they give you the money back. So it's an easier claim. They're often more likely to agree with that claim. If you go Section 75, the money to them is gone. So they give your money back and they now have to go and claim it back from in this case, Teletext. And that's why they're less likely to be an easy ride with this. They won't want to give you your money back unless they're certain they're going to get recouped from Teletext. So the answer to that question is yes, chargeback and Section 75 if it's a credit card. If you pay on your debit card, you can only do a chargeback. Section 75 does not apply to debit cards. The 120 days, of course, that only applies to the chargeback in answering that part of the question. So if they responded, Laura, to you about your claim, it must have been a chargeback claim because of this 120 days business. If it was a Section 75, that would be the second most ridiculous, or joint first ridiculous, I should say, reason for rejecting a Section 75 claim. And I'd love to know about it. I pay by debit card. Is it just as good as a credit card? Pretty much answered this, but I'll answer it again. No is the answer. A credit card's better. And the problem you may have, Sandra, is you may be over 120 days. And if you are, you've potentially lost the right to claim chargeback. I said potentially because I'm going to come back to it, because some people think they're over 120 days and they may not be, but I'll come back to that. I think this is the same question. What protection is there for those of us who pay by debit card? I'm going to come back to that in a moment. It's the chargeback scheme, but we'll talk about that in isolation in a moment. By the way, if I missed your question, forgive me. There's a lot coming in. I'll try and get as many as I can. I'll sweep through after this, and any I've missed, I'll try and post them up on my website where possible. Won't be a second. I think this is a follow-on also that I couldn't apply for Section 75. If you come back and tell me why they said that, I'll try and answer the question. They'll have to give you a reason. They can't just say, sorry, you can't apply for Section 75. There has to be a reason for it. I tried that with my bank. I felt more like a villain than the victim. Yep, many people say that, actually. I'm guessing you tried the chargeback with the bank, but if it was a Section 75, in either case, you shouldn't feel like the victim. Banks, credit card companies do not like chargeback or Section 75. Why? Because you give them work to do. They've now got to go and chase the company themselves, and they get arguments. And also, they don't like falling out with traders that use their services, such as accepting credit cards from them or debit card charges. So that's why they don't like it. You're not a villain. With Section 75, I know I've said it a few times, we've had it since 1974. It's there for a reason, to protect me, you, and all other consumers. It's your given right to make that claim if all the circumstances are right. So if you feel like a villain, don't worry about it. You're not. We paid on a credit card, but that person wasn't going on holiday with us. Are we still entitled payment? This is a great question as well. I'm guessing what you mean by this. When you say we paid on a credit card, I think you're saying someone else paid on their credit card for you. In those circumstances, you have a problem, because the rules are that you have to pay on your credit card for yourself. So there will be a good reason for them to reject that claim. Now, of course, some of you will be saying, well, but what about, say, Christmas, when I buy gifts for somebody? Does that mean I'm never going to be protected? You can argue this point, and often it will be successful. The problem with this one is, this is a situation where often the card provider will say no, and it's very difficult to argue against it. So my cautious response to this is, that's going to be difficult. My top tip on this question is, this is a reason why you should always use your own credit card to pay for holidays, because otherwise you can fall down this trap, this loophole, if you like, of a card provider being able to say, sorry, doesn't apply. Can I get my deposit back after cancelling instantly, as I have been told they broke security by booking me, 17, and not my partner, but putting him as lead? Jess, I probably need to see more information about this to answer the question. If you paid a deposit for a holiday and you cancelled it instantly for a good reason, I mean, if you did it online, of course, and you probably did, then you can go back and say the calling off period applies, and therefore claw your money back under those regulations. Now, often you can't do that with a flight booking and hotel bookings. Might be slightly different here because of the pandemic. This is why I need to see some more information about this, because it depends. Did you cancel only because you say you're 17 and your partner should have been the lead? May not be a good reason, because of course you knew you were 17 when you made the booking. But I'd need to see more information about that. My strong view is all of these holidays where there has been a cancellation because of the pandemic, you're entitled to your money back. So it may not matter about these other matters anyway. You may be entitled to this money back anyway, unless you tell me you've booked a holiday for 2022, in which case we don't know where we're going to be then. And at the moment, you won't be entitled to any money back. So come back and tell me a bit more about that one. Okay. I started a Section 75 back with Barclaycard in November, but unfortunately, they still haven't started my claim yet. Is that an exceptionally long time for a credit card? Answer, yes. Is it unusual at the moment? No. Lots of people telling me this, actually, because I'm always going about Section 75. I think I should be called Mr. Section 75. I'm sure the banks and the credit cards do not like me for it. So I'm always telling people about this. And for that reason, lots of people have been contacting me saying, I took your advice, the great advice, but they've not done anything, i.e. the card company or the bank. I think you'll find it's because there is such a huge backlog of claims at the moment. That's why they've not done anything. Let me give you a potential resolution, because I know many people will have this same question. If the card company takes too long, and I would probably say, here we are, 27th of January, 2021. If you made a Section 75 claim in November 2020, it's verging on too long now, especially if you've had no response. The next step is to go to the free Financial Ombudsman service. And the Financial Ombudsman, despite the fact they're called Financial Ombudsman, also deals with insurance claims and Section 75, because of course it's a financial product. So if you go to them and say, I've made a Section 75 claim, either it's been rejected and I do not agree with the rejection, or they've just not responded, the Ombudsman will open a case and look at it for you. My view, if you fall within all of the parameters that I've been saying this evening and what I've been writing about over the last few months, your claim with the Ombudsman will be successful. But be prepared. If you think your bank's taking a long time, the Financial Ombudsman is probably going to take a lot longer. Why? I'm not criticizing them. They have got a huge backlog of claims, but there is somewhere for you to go. Right, next question. Can you still apply to the courts with a Section 75 claim in place? That's a great question. The answer to the question is you can, but under English law, you are not allowed to double recover. Obvious one, really. So if you receive your refund via Section 75, you couldn't then go and obtain a refund or a judgment from the courts. The problem you could have if you try both is if you are successful with a Section 75 claim, you now will have to go and pull your case out of the courts, and there could be cost ramifications for that. So Teletext could say, well, we drafted a defense. You caused us to do all this work. We now want our costs of pulling this out. Now, I'm not going to get too technical with this, but in the small claims court, ordinarily, judges do not make what we call cost orders. That's because the small claims court is the court designed for consumers, designed for non-lawyers, and for it to be very easy. And therefore, they don't make draconian cost orders against consumers. So probably you'd be okay, but I can't promise it. So my advice would probably be try and do one at a time. Section 75 first would be my advice. Okay. I paid with a card. I don't have any more. I have changed banks. Same answer as before, actually, about this one, with the lady asked about fraudulent cards, as in when you rip them up. It doesn't matter. The fact that you paid with your card at the time means you're still protected. So if you're in that situation, go back and claim. I'm going to say this again. I keep hearing card providers saying, sorry, you can't claim because you've not got an account anymore. That's just nonsense. If you hear that, go back again. When I come to the end of Section 75 in a while, I'm going to tell you what you need to do if the card provider says no twice. If they say no once, don't give up. Don't go to the Financial Ombudsman. Try twice. And I'll tell you the next step very shortly. We can't get our money through card systems. So what can we do to pressurize our bank to take an action? I'm not entirely certain what you mean by that. So I think you might have to give me a bit more detail. Generally speaking, if it's a credit card purchase, then Section 75, as I keep saying, should work. If it's debit card, you try the chargeback scheme if it's within 120 days. I'm not sure what that means through the card system. It sounds like to me, the person who's giving me this question, maybe someone that operates a card machine themselves, maybe a trader. I'm not sure, but please come back and tell me. Do you mean that's a chargeback claim, or what is it? Let me know. Just trying to find some more. Section 75. Okay, so that may be all the Section 75. Forgive me if I've not answered yours. I will fly back through them in a while. Let's, before I move on to the next thing, let's finish off with this. So I said to you a minute ago, if you are rejected your Section 75 claim, the bank or the card provider comes back and says, sorry, no, there's no breach of contract, will be the main reason. My advice is now, armed with what I've told you this evening, go back and try again. Now, one of the things I've been hearing is from people telling me that they made a Section 75 claim perhaps 3, 4, 5 months ago, or perhaps longer ago, and they got rejected. There may be a good reason for that. And the reason for that is back then, the card providers still weren't really sure what the law was going to say during the pandemic. Was the pandemic going to mean that the laws were going to be relaxed? Well, I know the answer to that was always going to be no, but some people didn't know that. There were rumbles of the package travel regulations being relaxed, and that would have meant that the 14-day obligation to refund wouldn't have been a breach of contract, would have fallen by the wayside. So for this reason, some card providers were erring on the side of caution and not honoring Section 75 claims. Now, here we are some months later. We now know that's not the case. So if you go back, it may be that you'll just get your claim accepted immediately. Some people have been telling me that that's happened, not just with Teletext Holidays, but with many other brands, weddings and all sorts of things. So it's worth trying that. But also, it's worth going back again for the second time and just saying these words. There has been a breach of contract. Breach of contract is very important to say that, because I've not had my refund within 14 days and I didn't cancel the holiday provider cancelled. Those are the words you need to say, because now your card provider is faced with a consumer that knows what they're talking about and has mentioned the words breach of contract. And now I believe they'll say yes. Now, if they say no and it's your first time, try again. I've been telling people this advice for many years. I've been a lawyer for more than 20 years now. And of course, this law has been around for my whole career. And I've always told people this, and often it's worked. Many people have gone back on the second bite of the cherry and they've said yes. So try a second time. Now, what happens if you now get a second rejection? And by the way, I hope not many of you will, but if you do, I've already mentioned it, it's time to go off to the Financial Ombudsman. If you go online, you'll find their website easily in a search engine. You'll find that you can lodge your claim online. It's quite an easy process. That's the next step to take. But when you take that step, you should then go back to your card provider and tell them, I've now gone to the Financial Ombudsman. Why do I say that? Because they may decide to change their mind, because that's now going to cost them some money. And they may think, well, actually, this person's serious. We'll now accept the claim. Again, I've heard it happen. And go back to Teletext and tell them, I've now made a Section 75 claim. Please, can I invite you now to give me my refund? Now, I'm going to pause there for a moment, because one thing I've not heard from Teletext in recent times is any arguments that people are entitled to refunds. That is arguments that most people are entitled to refunds. They don't seem to be disagreeing with me or anyone else or what the law says, what the regulations say. They seem to be accepting that. Certainly, when I first wrote to them, one of the responses I got was, we understand the law. We understand our obligations. And I think they do. The situation here is they don't want to pay straight away, maybe because of cash flow. I don't know. I can't speculate. But they want to spread out the refunds. It may just be because they are so inundated. Lots of people on furlough, people are working at home, that maybe it's taking them longer than they want to. I know there's people screaming at the screen now saying, Dean, that's not the case. But I can't speculate on here. That's what it is. But it doesn't matter why. The fact of the matter is there's a breach of contract. So you should keep on inviting them to rectify that breach of contract. And by telling them you're making a Section 75 claim, tells them that you're taking some action. So I'm going to move on to chargeback. I know that many people have made chargeback claims. And give me one moment. So chargeback. Many people have made chargeback claims, and I know that many people have been told no, because you're outside of 120 days. If anyone's been refused chargeback for another reason, now's the time to ask me some questions about it so I can answer them. So I'm going to have a quick look through now, but do throw me some questions on chargeback if you have any. I don't think it's a chargeback claim, but I just want to look at this. I was told from Aqua Credit Card that MasterCard only give you one chance now for them to challenge your Section 75. That's an interesting question. I think what that means is when you make a Section 75 claim, the credit card company will go, in this case, to Teletext and ask them what their position is. Now, sometimes before they do that, they will simply make their decision and they'll come back to you and say, okay, yes, here's your money back, which of course, with a credit card is crediting the money back to your account. Then what happens is you find out that this has been reversed. And people often come to me and say, I've had a Section 75 claim reversed. Are they allowed to do that? That sounds strange. And the answer is, yes, they are, if they are presented with evidence from the trader, in this case, Teletext, that proves there's been no breach of contract. And that's why you have them reversed. And that's why I'm always interested to hear why card companies are telling you in this case there has been no breach of contract, because it will give us a sign as to what Teletext are saying. Here, what that's saying is the card company doesn't want to keep going backwards and forwards. But of course, it doesn't matter if that's their rule. If they come back and say, we won't look at this anymore, the law doesn't actually say that the card provider has to give you 2 or 3 bites at the cherry, or 2 or 3 chances to fight your case or to put your case forward. It doesn't say that. So the card company can make up its rules in that regard. But you've got a great protection because you can go after the Financial Ombudsman Service. That's a free right of redress. And again, the card providers don't like you doing that. So they are better off letting you put your case again. If you make your case and the card provider comes back and says, we are overturning your claim because we've had more evidence from, in this case, Teletext, they should give you that evidence and allow you to comment on it. So Martin, the answer to your question is yes, MasterCard can make that rule up, but it really is not in their interest to do so for the reasons why I've said. So Ben says, we paid in full by debit card. What sort of claims are we entitled to? Again, this is what we're talking about. This is the chargeback claim. So if you're within 120 days, you can go back and make a chargeback claim. If you're outside of 120 days, then technically you cannot. At the end of this bit, I'm going to tell you why, but technically it would mean you can't and you've lost the right to do that. See what else questions you've got. Again, forgive me if I'm missing your question. Okay, so the biggest problem we are seeing in the group is that they are stating they are a supplier. So I'm guessing this is in relation, this could come in relation to Section 75 or in relation to chargeback. Let's look at it in Section 75 for a moment. The thing I didn't tell you about Section 75, because it gets complicated, is for it to apply, you must have paid the supplier, if you like, direct. So if you are buying the holiday from Teletext, as you are, and you give them your credit card details, they take the payment, there's a direct payment. I'll give you an example when there's not a direct payment. If you pay via PayPal, if you pay via PayPal, you pay PayPal, and PayPal pays Teletext in this case, there's no direct link and it doesn't apply. Sometimes I'm hearing traders say, well, I was a facilitator. I organized everything. And therefore, when you made your payment, you were paying the people that I facilitated it for. So let's say I'm an organizer. You come to me because you want to book a holiday at the A hotel. And when you make your payment goes direct to the A hotel. You can't make a Section 75 claim against me. It would be against your credit card company, actually. But the credit card company would say, well, you didn't pay me direct, therefore there's no breach of contract because there's a break in the chain of causation, as us lawyers call it. I don't believe that's the situation here. I'll be interested to see that argument in writing to see how they have phrased it. If anyone's got that and they don't mind sharing it with me, not on here because it's too short, but on an email or on Twitter, then I'll be interested to see that and I'll be able to answer that question better. Because it really depends how they put the argument in relation to how I answer the question. So the bank is asking for evidence, but Teletext are not providing it. I think this is an extension of the question earlier. The bank doesn't need to see evidence from Teletext because really, if you make a claim, whether it's a chargeback or a Section 75 claim, the bank can make its decision on what you say. If Teletext refuse to provide evidence to the bank or the credit card company, then in my mind, that by default should mean that you're successful because they've not given a successful challenge. So that just shouldn't matter. That's a case for me to go to the financial ombudsman with. So if that's a Section 75 claim, I think you should take that to the financial ombudsman because that's not a good reason to reject your claim. Let me just quickly bring this one up. It's interesting. They told me it was not a package holiday, but just checked ATOL certificate they sent me says it is a package holiday. And I'm pretty sure it is. I would go back to them with a photocopy of that and say, you sold me this package holiday. It is a package holiday. Why are you saying it's not? And see what they come back and say. I can't make accusations on here, but it may be they're saying that just to fend you off for a while. I couldn't possibly say. But it appears to me that it's highly likely that this is a package holiday. So I think you're probably in the right. As I say, if the ATOL certificate says it, it most probably is. Perhaps you may want to get in contact with the CAA. This time I have said the right words. It's not CMA, it's CAA, the Civil Aviation Authority, because it operates and runs the ATOL scheme, and ask what it makes of that that response. Be interesting to see. Okay, let's come to this. If I might wander off chargeback, by the way, but I think it's going to be easier for me because there's so many questions coming in. Where do you stand if you have accepted a voucher from the airline, but only due to being lied to by TT when they said they hadn't sold a package holiday and weren't liable for the flights and told me to go to the airline directly? It was a package. It's on my ATOL certificate. I'm going to break this question down into a few things. So you could have gone direct to the airline and try to claim from them. You should go through Teletext Holidays, not the airline. You didn't have to accept a voucher. The law in relation to cancelled flights is clear. You can accept one, but if you want a cash refund, you're entitled to it. But if you have let's go to the real part of your question here is you've been misled. So Christopher, my understanding here is you've only accepted a voucher because you thought you had no choice. You thought it wasn't a package holiday that you had. Well, you should never be misled. This is one of the fundamental things about consumer laws and consumer protections, is that consumers should never be misled. If you've accepted that voucher on false pretenses, and let me just put another disclaimer in here, I don't know if you did. I've not seen your contract or any of your papers. It may well be that it wasn't a package holiday. It may well be that Teletext are correct. But if they're not, and let's talk in theory here, if in theory they're not incorrect about this and it's not a package holiday, or then of course there's been no misleading. But if they were wrong, then my view is you can go back and say, actually, I don't want the voucher. I want my cash refund. And it will be a slam dunk case in that situation, and Teletext will have to give your money back. So I wouldn't worry about that. By the way, not the first time I've heard that question, and probably isn't going to be the last. Again, I'm coming off chargeback, so I think I'm probably just going to have to ask any questions now. So TT have lied to the court and told them I cancelled my holiday. Again, I'm not saying they did lie, but if you're correct, then of course it's a criminal offence to lie to a court if you have done so under what's called a statement of truth. So if they've put that in a defence which they've signed to say is true, or in a witness statement, then they will be in what we call contempt of court, and you ought to gather the information that proves that you didn't cancel and tell the court, because they will take that extremely seriously. Let's look at why they may be saying this, because one of the other things that I've been telling people throughout the whole pandemic is if you have something booked, holiday, wedding, or any other type of event, the number one thing not to do is cancel. If you cancel, then the trader in here, the Teletext Holidays, can turn around and say, you cancelled, you've lost your money. It's important that they cancel. I have been hearing on many occasions, not just Teletext, I mean, many other brands have said, well, you cancelled this holiday or you cancelled this wedding, therefore you can't claim. And in fact, it transpired that either the consumer didn't do it or didn't realize. So if you're certain that you didn't cancel, then you should be fine. Your case is obviously in court, so it's going to be down to a judge to decide. And all I'll say is a judge in a civil court makes his or her decision on what we call the balance of probabilities. That means whose story is more likely. Is it more likely that Catherine cancelled this holiday, or is it more likely that Teletext did it? Now, the starting point will always be to err on the side of caution and be on the side of the consumer. And here we've got a pandemic. We know loads of holidays have been cancelled. So if your holiday was due to take place during the pandemic, during the lockdowns or restrictions when planes haven't been flying, then it's highly unlikely, in my opinion, that a judge is going to decide that you cancelled the holiday. Because why would you? If, on the other hand, you jumped the gun before we had cancellations of holidays and cancelled, then you're going to have a problem. So I think that's what you need to do, is look very closely what actually happened, build a timeline. I'm going to come back to timeline shortly when I talk about court proceedings, and see when did you get emails, what did you say, when did you say it, and see what happens there. I'm going to jump to this quick. I was going to deal with this at the end, but I've just seen it, and it's an interesting question that I was going to raise. So Keith says, would a class action be feasible for our refunds, as Teletext Holidays are not yet in liquidation or bankruptcy? So certainly I'm not saying they ever will be in liquidation. I don't know that. I can't make that allegation. Would a class action be feasible? Yes, it of course would be. The Consumer Rights Act, it came out in 2015. And of course, anyone who listens to me regularly will know these are my favorite words, Consumer Rights Act, because it protects us all greatly. And there's loads of wonderful things in this law. But one of the things that's not been used that much yet is class actions, or as we call them in the UK, group litigation orders. Class actions is what the Americans use. It's their term. You see it in lots of movies. Like Erin Brockovich, for example, one of my favorite movies. But the answer to the question is, and I'm going off course here, is yes, you can do that where you have a situation where there's lots of consumers with the same problem, the same principles in law, then you can all club together and launch a class action. This is one of those cases, because it appears to me you're all arguing the same thing. I booked a holiday. I paid some money. It's had to be cancelled because of a pandemic. You had 14 days to refund, give my money back. That's what the law says, and I now don't have my money back. You're all saying, or most of you are saying, the same thing. So the answer, Keith, is yes, you could do that. If everyone wanted to club together and do that, it's feasible. There are hoops to jump through. I won't go into this in too much detail, but you need permission from the court to do it. I think this case would get permission. Then needs to be a kind of a lead case. You have to all synchronize and everything else. There's a couple of groups here, and there's a few people in these groups that have been brilliant ambassadors for these claims, and who have been really pushing this. So you've got all the ingredients of a great claim here, and it would help. Let me mention something about liquidation. And again, I was going to do this at the end, but I'm going to do it now. As I said, Teletext, as far as I'm concerned or aware, are not in liquidation, but they could be. They could be, because if all of you or any of you were to go to them and say, you owe me money, it's more than £750, which I know from lots of cases you've told me about, it is in most cases, that would mean you could present what we call a winding up petition. Now, a winding up petition is a document that basically starts a process to put a company into liquidation. It is a draconian step. It's a serious matter. And a company on the end of one of these winding up petitions does not want to see that go anywhere. They must stop that as soon as possible. Because if they've got lending, if they've got an overdraft, a bank loan, a loan from another company, anything like this, those lenders find out about these things and normally pull the plug. They can call their money back in, or they get concerned. So this is something that a trader would not like to be on the end of. Now, the downside to this would be it's complex. If Teletext in this case were to come back and put a feasible defense in and were able to overcome your winding up petition, the courts in that case would most likely order you to pay their costs of defending it. And those costs can be a lot of money. It could be £10,000, £15,000, maybe more. And also, it's quite expensive to launch it in the first place. Typically, you'll pay £1,600 just to issue a winding up petition. But the reason why I'm mentioning this now is because Keith talks about a class action. So the other thing that could happen here is a whole group of you could get together and do a joint winding up petition. It's not quite as easy as that. I'm not going to go into too much detail, but it can be done. And therefore, there's one fee for the winding up petition. And there are strength in numbers. There's no doubt about that. Now, I should just say this, because anyone who knows anything about liquidations may be saying to the screen now, I can't hear you, but maybe saying to me, what about a statutory demand? Don't you have to do that first? Ordinarily, you do. And the reason for that is that with winding up petitions, you have to be able to prove that the debt is a real debt, can't be disputed. And the statutory demand, which is basically a piece of paper that you send to the likes of Teletext saying, you owe me money, and if you don't defend it now, I'm going to do a winding up petition, is evidence. But the reason why I didn't mention it at the start is that here's a case where it appears to me all of you, or most of you, have been told you're going to get your refund. They're not arguing that you're owed a refund. They're just not giving it to you on time. So they've agreed all these debts. This, in my view, is their number one weakness, because they have put themselves into a situation where I know at least 900 of you, maybe more, are owed money. And any one of you, if that money is over £750, could go in and press the nuclear button and ask for a winding up petition and put them out of business. So the question now that some of you are asking me, to the screen again, I can't hear it, but I'm telepathic, is, well, if that happened and if they went out of business, would we all lose our money? And the answer to that question, just to give you comfort, is no, you wouldn't. You wouldn't, because you're protected by ATOL, and ATOL would refund your money. You're also protected by APTA, and you're also protected by something else. And I'm going to ask a little bit more audience participation now, before I waffle on about the law a bit more. So who noticed when they booked their holiday with Teletext Holidays that they are protected or part of an organization called the Travel Protection Plan, TTP, they're known in short? Who noticed that, and who thought that gives me some comfort when booking? If that's you, just type down I did or something like that. And I'll tell you why I'm asking this in a minute. And while you give me some answers, I'm going to take a breath for one moment. I'll take a yes as meaning yes. Yep. So as a few people, some saying no, but most saying yes. Some of you may not have noticed. Some of you may not cared about that. You just booked the holiday. But some of you certainly would have gone to the website. It's quite prominent, this. If you want to have a look after this, go to their website. Look at the top left corner and it says protect. I think it's something like protected by TTP. And anyone who likes to do due diligence on these things, and by the way, from this moment onwards, I'm telling everyone, do your due diligence of whoever you buy from. But anyone who used to like doing that and looked into what this TTP is all about would have found that actually it gives you quite a lot of protection. So I'm going to pause for a moment going over questions and just tell you a bit about this, because I think this is quite important. So I'm looking over here because I've got it written down on another screen. So if you go to their website, and again, it's the Travel Trust Association. I think I might have this to put on the screen for you. There you go. There's the website. The Travel Network Group is another name for them. That's their website. If you go to that link, you will find some FAQs. And those FAQs explain the protection that you get as a consumer when you book a holiday via one of their members. Teletext is one of their members. And this is what you will see. And I'm going to read it to you. Just give me one moment. Well, the first thing you'll find is they will tell you that when you pay your money to Teletext, they will have to put that money into a trust account. And everyone's entering into a contract with you that they will do that. Then the money in that trust account can only be used to pay for your holiday. Let's stop there. Why is that important? Well, because the moment you put your money into that trust account, that means Teletext or anyone else who's a member of this scheme can't use it to run their company. They can only use it to pay for your holiday. And if they stick to that arrangement and that company, in this case Teletext, goes into liquidation or administration, the liquidator or the administrator, this is the official people or bodies that run the company in liquidation, can't touch the money. It's protected. So the TTP, as I'm going to call them, they say, well, if it all goes wrong, it goes bust, we'll give your money back. Well, why do they say that? Because they know that if their member, in this case Teletext, if they stick to the rules, the money be sat there in a trust account. So they won't have to put the money in their pocket, but they're giving you that guarantee. So where am I going with this? Well, we know that in most of your cases, I think money's been paid over to hotels, more likely to airlines. We know that Teletext have said they've not had money back from airlines. And we know that some of you tell me, and I can't verify it, that you know the airlines have paid the money back. Now, cynics say, well, they've paid the money back. Maybe it's EasyJet, Ryanair, whoever it is. They've paid the money back to Teletext, and they're using it to run their company. That's why I've not got the money. Well, if you read this website that I've just put up there, you will find out that they shouldn't be doing that. By the way, I'm not saying they are doing it. I don't know. But does it not warrant an investigation from the Competition and Markets Authority, the CMA? In my view, yes, because this company has basically contracted and promised you as their customer that all your money will be in a trust account. So when the money gets paid back by the airline, where should it go? In the trust account. And it should go from the trust account back to you. Let's bring this back to TTP, because I realize I'm waffling. So I'm going to read this part of you. Therefore, the trust account plus the guarantee will ensure that all money which you have paid is safely protected and available to reimburse the money paid. When you make a booking, you will be supplied with a guarantee certificate. You can see terms of the guarantee and it gives you the guarantee. And if you press the link, you'll see a copy of the guarantee. Now, I'm guessing that all of you received one of these guarantees, one of these certificates from TTP, because apparently these guys are a member. They are a member. I've checked it. So in my mind, anyone who can prove that the airline has paid the money back, in my mind, that means you can now go to the TTP and say, you now need to give my money back because I've not had it back from Teletext. That's worth trying. I think it's definitely something which is a course of action to take. Now, before I leave TTP alone, let me tell you something else interesting about this organization, because they did have a code of conduct on their website. And that code of conduct is the code of conduct that all of their members, including Teletext, have to abide by. It seems to have disappeared. I think, I'm not saying it has, but I can't find it anywhere. But there's something very interesting on this FAQ page, and I'm going to read it to you. It says, question, how long will I have to wait for my refund? Well, isn't that the question we're all asking? It's certainly the question you're all asking. Here's the answer. Currently, and when I say currently, I mean during the pandemic, because this is under their pandemic page, there is no hard and fast rule. If your travel company is able to provide a cash refund, please be patient. They are dealing with a huge number of customers, and with offices closed and staff working from home, it's a real challenge. And at the moment, it's not unreasonable at the moment, they say at the moment twice, I didn't repeat myself, to expect the process to take upwards, ready for it, of a month. Not 12 months, not 10 months, a month. Now, of course, a month is still twice as long as it should take, but nowhere near as long as what you've all waited. So again, even this organization that they're a member of seems to say it's going to take longer at the moment, but a month. And I think you need to pick up on these words. You're going to be firing all the emails and letters out that you possibly can. One of them is going to go to these guys at TTP, as I keep referring to them, but I think you know who I'm talking about now, the Travel Network Group. And you're going to say to them, I booked my holiday on the strength of your guarantee. You making me a protected consumer. Read their site. You'll be amazed how much protection you've got, but you're not seeing any of it. So you need to go and ask them, where's my money? As well as asking Teletext. Another email you're going to send is to Teletext to ask them again, where's my money? And you may want to go to the CMA. I've done it for you, but you may want to do that as well to push them, where's my money? So anyway, let's come back to some of your questions. I never made a chargeback claim as I was over 120 days, cancelled in May. I was told I'd be refunded. Can I still make a claim? Abby, lots of people in this situation. And I guess what you're saying is you didn't make your claim because these guys told you get your money back. You didn't think you needed to make your claim. It's a real issue. Now, I spoke to the financial ombudsman about this. I thought they were going to say to me, no, if they're over the 120 days, nothing they can do. But to my surprise, the response I got was, tell people if they think they're over 120 days, they may not be. Sometimes it's more complex than that. So lodge their claim with us anyway. So if you made a chargeback claim and you were told you're out of time, still worth trying the financial ombudsman, because from what they're telling me, they are sometimes finding in people's favor. It's another route to go down. Let's face it, we've got to try everything here. So that's a route you could try. Some of these I would love to put on the screen, but I won't because I'm going to get in trouble. So forgive me, but some of the comments you're making, I understand the anger. Just going to bring this up from Haley. Trust account, so why can't they refund back to the trust? Yes, that's my point. When they made the payment to, say, EasyJet, this is not a pop at EasyJet, obviously. When they made the payment to the likes of EasyJet, when EasyJet paid the money back, this is really important, so I'm going to say it again. That money should have gone back into the trust account. It should not have gone into any other account. It may well have done. I make no allegations because maybe it did. If it didn't, then there is a breach. There's a breach of trust and confidence, as us lawyers like to call it. That's serious. There's a breach of the rules of this TTP outfit I've been mentioning. And there's a breach of the contract with you as well. Lots of breaches going on. So that's something you want to bring out in court proceedings. And I think it's worth asking the question. Maybe tomorrow, all of you should be writing to Teletext and saying, can you confirm if you've had money back from any suppliers, has it gone into the trust account? Let's see what they say. Probably no one's asked that question, but please do. Would a trust account be their company credit card? No, it wouldn't be. They might like to think it is, but definitely not. The trust account is the trust account. So definitely not. Good question. Okay, this is an interesting one. So Teletext have told the court they are refunding in date order, but they are definitely not. Look, they've told me this as well, and I know they've told many people this. And what they're trying to say is, look, bear with us. We are doing what we can do. We'll get your money back. Let's just say this: all traders in this climate have struggled, and all are doing their best. One thing I will say here: don't shoot me down for this. They are refunding people. They're not refusing. So far as I know, unless anyone tells me differently on here tonight, I've not heard from anyone come to me and say, I've been rejected or refused my refund. No one's told me that. If I'm wrong, please tell me. But what they're saying is, we'll get to you soon. I agree. It doesn't look like they're refunding in date order because too many of you have put evidence on the likes of Twitter to confirm that they're not. And by the way, the reason why I put this question up is a very good reason for this. So what? So what if they've told the court they're doing it in date order? It's not a defense. So if Teletext have told you in court proceedings that we are going to refund you, but it's going in date order, that's not a defense. That's a reason for a judge to give you what we call judgment, because the fact of the matter is they had to give your money back in 14 days and they didn't do it. What this is what lawyers call is an admission. They're admitting they owe you the money, but they can't pay it. What that also is an admission that perhaps, just perhaps, they ought to be in liquidation. Don't know, not making any allegations, just an observation. I'm going to go through a few more queries here. Lots of people telling me they don't reply. I'm going to come back to what you do about that in a moment. In fact, a lot of people are saying this. A lot of people telling me they're not going in date order. Yep, I think we know that. They're definitely not going in date order. So one thing I want to say here about this date order, if they've spoken to the CMA, I don't know if they have. I'm guessing they probably have. Then it's likely that they have told the CMA, we are refunding, we're doing it in date order. Now, of course, this will be evidence for the CMA this evening that may not be true. Now, there may be some cases where they pull things out of date order on purpose. And this leads me neatly to the last part of what I want to talk about this evening, which is court proceedings. Because if you issue court proceedings against Teletext, it is inevitable that they are going to push you up the queue. There will definitely be people that have experienced this. And the reason for that is, number one, it will cost them money to put a defense in. And they don't have a defense, so that's difficult for them. And secondly, they will not want county court judgments all over the place against their name. Because if they get that, it means it's very hard to get funding in the future if they need to raise money for working capital and other things. So they won't want that to happen. So this comes back down to this group litigation order, or class action, as someone called it earlier. It's another reason why that could be a good thing. You would have to get a ringleader to organize it, or if not, it's another good reason why going on to the small claims court, it's an online process these days. You'll find the website is very, very easy to do, could be a good thing because it will push them to give you your refund. But let me say this, they do get 14 days to acknowledge your claim. They get another 14 days to put a defense in. So what they could do is they could see it as an opportunity to drag your claim out, your refund, for another 28 days, and then they'll pay you on day 27. So if you are someone who booked their holiday back right at the start of this, and you're hearing of people getting refunds in that period, it's not worth doing court proceedings because you may delay it further. I'm saying may, I don't know. If you booked in the second half of 2020 and they're nowhere near those, and again, that's me talking like they're doing it in date order, I know you're telling me they're not, then it probably is. But let me give you a couple of tips about issuing proceedings in the small claims court in this matter. I have seen some people issue a claim against Teletext Holidays. Don't do that. That's not what they're called. That's their trading name. You need to do it against their actual name. which is, I think, is Truly Travel Limited. Just check that, because I'm saying that from memory, because I always call them Teletext as well. But you must call them by the right name, because if you don't do that, you're suing a non-entity or the wrong party, and you'll give them a reason to get the claim kicked out. And I have heard it happen, by the way. Also, make sure that you tell your story properly in paragraph numbers. Paragraph 1, I booked a holiday with the defendant on, I believe it was a package holiday. Give all the details of the holiday. Explain it was cancelled by them. Make sure you explain they cancelled, not you. And explain that under the regulations, that's the package travel regulations, they should have refunded you in 14 days. Here you are now, X days, weeks, months, whatever it is later. I know it's going to be months. And they are therefore in breach of contract. So you are claiming your money plus costs of bringing these proceedings. That's pretty much what you need to do. Now, just to help, I'm going to do a template for this on my theconsumerlawyer.blog website, just so you can follow it. I would urge you to follow it, because many people go off to the small claims court. And even though it's supposed to be pro-consumer, and it is, sometimes they trip up by making these silly little mistakes. So let's make sure you don't do that as well. I'm going to just quickly see if there's any more questions. Give me a moment. I'm going to see if there's any more burning questions here before we wrap up. I really hope this has been helpful. It was designed to be. Let me just bring this question up, actually. Please, where do I stand having my 14 days notice ignored? I guess what you're saying to me is you've sent what we call a letter before action. You gave them 14 days to respond, and you've not heard anything. Well, that means you now need to go to the small claims court. And you can tell the court that you sent them a letter, they ignored you, now you're in the court. So that's all you can do. There's no other right, but it gives you a good reason to do it. Should just say this. I think all of you have done this, but always before you go to court, you should always tell the person that you want to take to court that they owe you money and what you want from them, i.e. a letter before action. So if you haven't formally told them this, I'm sure you all have, make sure you do that first, because they have to be given the opportunity before you go to court. I actually don't think it's going to apply to any of you. And if they've come to you and said, we're going to give you your refund on X date, and they've breached it, then you can go straight to court. There are some things in here I'd love to put on the screen, but I won't. Catherine, thank you. I'm glad I've made your night. Hopefully we are going to get somewhere. But by the way, I did see it was someone's 50th birthday on here, quite a long way up. So happy 50th birthday to you as well. And I hope you get your wish, which is your refund for your birthday. I hope you absolutely do. They ought to be giving your money back. Let me say this. Look, I strongly believe everyone is going to get their money back. It's a matter of when you're going to get your money back, not if. What I'm looking at here really is what strategies can we put in place to get it back quicker. And for me, it's let's get the CMA involved. There's been a great reaction this evening of all your responses. I think they'll take notice of this, and let's see what else we can do. You all clubbing together will help. Perhaps winding up petitions. Word of caution again with that, can be complex, can be expensive, isn't something to do lightly. But look, we all know there's bound to be at least one person watching this on behalf of Teletext Holidays. And let me say this to you, you need to go back with the message that these consumers need to be paid, and you are now running the risk that someone out of this 900 plus, I believe it is, could issue a winding up petition. You don't want that to happen. Therefore, my advice to Teletext is, even if you can't afford to pay everyone now, I don't know that's the case, I make no allegations, just tell everybody. Tell them when they're going to get their money, so everyone can sit back and relax and not worry about going to court. No one should have had to have worried about going to court, but people have. And this is what I'm telling the CMA. This is what we call, again, consumer detriment, and it shouldn't be there. I hope that's been useful. I hope that some of that advice is going to help. I hope you're all going to get your refund. I'm not going anywhere. I'm still around for you to ask questions. I'm back on LBC this Friday, 9 p.m. If anyone wants to ask me any more questions about winding up petitions, issuing court proceedings, Section 75, or anything else like that, the number's on the screen now, 0345 6060 973. Don't call it till 9 o'clock Friday. I'm on air for 1 hour, 9 till 10. I'll answer your questions if you call me. Also, next week, I'm starting something similar to this every Monday evening on YouTube, a live Q&A session for all things consumer and all things legal, where I'll be going through as many questions and answers as I can and giving updates on the current consumer news, which at the moment is a daily event. There's loads of news. So again, if you've got any questions, you don't get me on LBC Friday, call me on Monday or send me a tweet. I also put a lot of information on my Twitter. For anyone that doesn't follow me, it's on the screen there, at Dean Dunham. Again, I hope it's been useful. I hope you all get your money, and I wish you well. Stay safe, and I hope this has been useful. And thanks very much, and good evening to all of you.